ladies and gentlemen. My name is Heather Rosing, and I am on the Board of Trustees of the State Bar of California. My apologies for being a few minutes late. I came up from San Diego for today's hearing. We appreciate all of you being here. I'm also the chairperson of the RAD committee. It's the board-level committee on regulation, admissions, and discipline, and I'm here in that capacity as well. So I welcome you all to the annual State Bar public hearing on admissions, competence, and discipline in Los Angeles. Again, thank you for being here today.
We have a court reporter present to transcribe all of the oral testimony presented today. And this testimony, together with any written comments that are received, will be made available to the full Board of Trustees and to all of the members of the Committee on Regulation, Admissions, and Discipline Oversight.
Let me introduce the other people who are with us for this event. To my immediate left is Jane Kim, Chief Trial Counsel. Colin Wong on the end here, Chief Administrative Officer of the State Bar Court. And at the end here we have Randy DeFritorum, Director of Professional Competence Department of the State Bar. And to my immediate right, Gail Murphy, Senior Director of Admissions.
We understand that some of you are here to discuss your experience with a specific attorney. And while it is not the purpose of this hearing to register complaints,
we do understand and appreciate that you have taken time from your busy schedules to be here.
And therefore, we respectfully request that if you discuss your experiences with a specific attorney,
that you refrain from using the attorney's name in discussing those experiences.
Until a complaint is filed in the State Bar Court, it is a confidential matter.
We also have limited time today, and we have a number of people in the audience. So we please ask that you complete your testimony within 15 minutes or less.
Good morning. I'm an attorney in private practice in California. I defended attorneys in the State Bar Court. I've also assisted consumers in pursuing complaints against attorneys with the State Bar. One of the types of complaints which we frequently encounter is a complaint that attorney is charged an unconscionable fee for services rendered. Well, recently, on November 6, 2013, the Second District Court of Appeal issued an unpublished opinion affirming a fee dispute award by the State Bar fee dispute arbitrators in favor of the client and against the attorney. And in that opinion, the court recounted that the fee dispute panel determined that the attorney had repeatedly pursued meritless litigation in representing his clients in the underlying civil action, and that the clients had paid the attorney $735,481.32 in attorney's fees and costs. The panel found that the total amount which reasonably should have been charged was only $8,500, and ordered that the attorney refund to the clients the sum of $726,981.32. Additionally, the panel found that the attorney willfully failed to appear at the arbitration hearing and to produce his file as ordered to do so by the arbitrators. A complaint was filed with the State Bar against this attorney for violation of 4-200A, charging an unconscionable fee. It's kind of difficult to imagine how an overcharge of $726,981.32 would not be considered to be unconscionable. Additionally, it was asserted that the attorney's failure to appear at the arbitration and to produce his client file as ordered to do so by the arbitrators was disobedience of a court order, which is an additional violation under the rules and the State Bar Act. The attorney has a duty to comply with court orders and to uphold the law. In addition, attorneys are required by the State Bar Act to participate in arbitration if it's demanded by the client. It's not voluntary. If the client demands arbitration, the attorney has no choice but to participate. It's made mandatory. We asserted that as an additional violation, that the attorney refused to participate despite the fact participation is made mandatory under the State Bar Act. And finally, the attorney never paid the judgment, and under the rules, the attorney is supposed to be put on involuntary status for disobedience of a court award affirming the arbitration's award to pay the judgment. The complaint was filed with the State Bar. I actually made the complaint. And the State Bar's reaction was, well, first of all, the parties who were directly involved in the underlying civil litigation who were overcharged didn't file any complaint with the bar, so the bar didn't really want to look at it for that reason. Additionally, investigators determined that there were insufficient evidence to determine that there was any violation that was committed. Notwithstanding the fact that the State Bar's own fee dispute panel made that determination, notwithstanding the fact that the Superior Court confirmed the award, and notwithstanding the fact that the Second District Court of Appeal upheld that award and affirmed the trial court's judgment. So it's kind of difficult to understand why the bar would not be interested in the issue, especially considering the significant amount of overcharge that was involved. If that kind of an amount's not going to attract the bar's attention, it would seem it doesn't matter what the amount is. The bar simply doesn't have an interest in these types of violations.
3 years ago, I was bathing my 3 kids in a hallway bathroom when I heard a banging that wouldn't stop for about 20 minutes. And my wife had just delivered our youngest child, and I wasn't able to leave my kids in the bathtub unattended. And as a result, the banging got progressively louder. And I confronted a man at the doorway and asked him to leave. He wouldn't leave. And I thought it might be, someone that my wife had an altercation with in the few weeks prior, in a car accident or something of that sort. I'm a husband, I'm a father, I have a teaching credential, I'm a licensed real estate broker, I have a licensed insurance license, excuse me, and had no reason to believe that I essentially knew nothing of what was taking place. When I opened the door, I was confronted by someone that was holding something, seemed to be holding something behind his back. And I tried to call 911, and I wasn't able to do that. My phone, and I have an iPhone in Encinitas, and our service is not the best. And fearing for my wife's safety as well as the safety of my family, I went and got my shotgun out, put some shells in my back pocket, and went out to confront the person. And I thought he was just a simple trespasser, and I instructed him to leave. He said, essentially, you have no idea who you're dealing with, and you can't have me arrested for trespassing. Then he reaches for something suddenly, and I jerk back, and he presents a subpoena, basically throws a subpoena at my feet. And actually not at my feet, he reaches out, and I pull it out of his hand. Essentially what happened as a result of this experience is, because I had assured him I was going to call law enforcement, he proactively called before I could because my phone didn't work. And the next thing I know, I'm in the back of a sheriff's patrol unit, and I'm being driven to the same substation I visited when I was in kindergarten 30 years ago. And I was charged with assault with a deadly weapon, as well as a misdemeanor charge of brandishing a firearm. And the district attorney in San Diego has a very harsh disposition toward gun cases, as well they should in most instances. And she enhanced the charges and added a felony enhancement for the use of a firearm, as well as a strike And this was all over essentially a delinquent homeowners association issue. I had just started my homeowners association payments a month before. I had no reason to believe this was taking place. Anyway, so we all have in our system, we have these safeguards to protect ourselves from being in this position. I got the best attorney I could get from the public defender's office. I conducted my own investigation and later determined that there were actually 5 corroborating witnesses on the night in question that would all testify that this man was belligerent and obnoxious, and he had a manner that was very frightening. He weighed 300 pounds. I actually described him in court as saying that he resembled John Wayne Gacy. But in the final analysis, because of a bench mistake, I took the case all the way to trial. I was assured that by the DA's office that they had a 94% conviction rate. That's actually 98% in San Diego with respect to violent felonies. So I faced down a very tough time for 9 months, and I was acquitted of the felony charge, but because of a bench error, because the judge made a mistake, an honest error, as far as not giving my defense counsel the opportunity to present my affirmative right of self-defense with respect to the misdemeanor. I was convicted of the misdemeanor because I had admitted I held a firearm and I swore at the guy to tell the guy to leave. So as a result, I hired who I thought was going to be a great lawyer to protect my interests on the appeal. I mean, I'd come this far, facing 15 years in prison, hired a former deputy district attorney in San Diego, whose name doesn't need to be repeated. He assured me I had a compelling case. His father was a judge on the appellate court, is a judge at the 4th DCA. And if you meet this attorney and you visit with him, you sit down and you think, you know, this person really cares about my case. He understands the issues. He's in a position to make a compelling argument in my favor. And he gave me no reason to believe that I hadn't hired a great advocate. I'd later learn that, in fact, something happened to this individual during that period. And for whatever reason, he wasn't the same person when I saw him again at my sentencing. His assertions that I had a compelling case changed and transformed. By the time I got to the day of the sentencing, he said, well, actually, I know I took your money, and I know we discussed your interest in appealing, but now you have no case. So I was beside myself, and I asked him if he'd procured the transcript, because that's essential in any appellate when you're appealing anything. And he said, don't worry, I'm going to get it for you, and we'll continue the appeal. I accepted the sentence of 120 days custody with the San Diego Sheriff's Department. It turns out I was assigned to work furlough, with the understanding that he was working in earnest to appeal. And in fact, that's the last time I talked to him. And I became progressively more stressed about what had happened. And as a licensed real estate broker, you can't show property while you're in custody. And only until later did I learn that this individual failed to file a one-page notice of appeal. It was a simple one-page notice of misdemeanor appeal. He'd assured me he'd filed it. I had no reason objectively to believe that when a licensed professional, a member of your organization for 18 years, if someone tells you that they've done something, you naturally have no reason to disbelieve them. Well, in fact, he didn't. And while I was in custody, which was an environment for me that I certainly didn't, it was a fish out of water experience, I can assure you that much. And most of the folks that I was in custody with were being disciplined for DUI matters. I actually had a conversation with one of my bunkmates that I should look into my attorney's background because his lawyer knew my lawyer, and in fact, that lawyer that I had trusted, had been fired after his 3rd DUI-related issue by the San Diego District Attorney's Office. I found that really hard to believe, but actually, after I got out and I collected myself, I filed a California Public Records Act request with the San Diego City Attorney's Office, and I've actually provided that to you and your colleagues as far as looking into why this man's 3 convictions with respect to DUI were not brought to the attention of the State Bar. I'm here as someone who suffered in silence for 3 months with a group of folks that I would ordinarily not find myself in close habitation with. I don't have a bar card. I've talked to thousands of lawyers across the country in the last few years and probably interviewed 50 or so to represent me in my case. And I can say that there's no other individual here that as far as I'm aware, that would bring this issue to your attention. I don't see an attorney standing up, waving the flag and saying, we should apprise the public when attorneys have been convicted. And I respect the fellow's representation as far as the importance of publishing convictions as opposed to allegations. But I'm asking that the State Bar consider publishing convictions on the State Bar website when a member of the bar has been convicted of a DUI or another substance-related offense, which calls into question their judgment to practice law in the first place. It should be available to the public.
Now, changing hats for a second, attorneys deserve a fair shake as well if they come into contact with the disciplinary system. You have a very serious problem that the State Bar Court refuses to grant fee waivers on appeals to the appellate division if the attorney is indigent. That is what happened in my case. The attorney has an absolute right, the client had an absolute right to appeal in the appellate division of the State Bar Court, but would not be heard by the judge because she would not pay for a transcript which she could not afford. All courts provide for fee waivers, including the Supreme Court. The government code requires fee waivers for indigent people. The State Bar Court refuses to grant such waivers. As a result of that, my client was denied her right to appeal in the State Bar Court and was denied her right to any meaningful review before the California Supreme Court because the California Supreme Court requires a transcript as well. And there was nothing to cite to because she couldn't afford it. As a matter of fact, the State Bar Court wanted to charge my client $7,000 for the transcript, only charged the State Bar $750 for the same transcript. And the last comment I want to make is there needs to be some kind of a provision similar to an independent inspector general to investigate misconduct by people who work in the State Bar and in the State Bar Court. In my particular case, the trial counsel's office admitted later, after the trial, that it had withheld 6,000 pages of evidence that could have affected the outcome of my client's case, which we were never had the opportunity to review. There was no place to go to file a complaint. State trial counsel didn't want to investigate that, and they're not going to investigate their own employees objectively. So you need to have some outside mechanism where someone can go to file a complaint about improper practices which are being committed within the State Bar Court and the State Bar.
I'm here to discuss some very significant problems that are been generalized across the system, and in particular point to 3 recent cases, all unpublished, in which various attorneys were completely exonerated by the State Bar Court, and one of which, McHugh, is about as shocking an example of prosecutorial misconduct as one could hope to imagine. The cases that are listed at the bottom of the first page are In re McHugh, In re Robinson, and In re Johnson. I don't know any of these attorneys, never met them. Everything I know about them is matters I pulled up from the public record. In McHugh, Judge Miles found the case brought by the Office of Trial Counsel was essentially predicated on outright rise in the pleading. The problem that we have here is that there has been developing is that under the bar's new policy of zero tolerance and accelerating of the efforts to prosecute everyone and everything, they are running complete roughshod over due process rights. The other problem that I need to bring to your attention is the fact that there is now a process of intimidation being brought forward against me and other innocent attorneys, which is the use of the publicity features such as the consumer alert and the general posting of disciplinary charges on the website for an individual. In the McHugh case, this gentleman had a consumer alert put up against him, and because of the consumer alert and because of the bar's action, if you look under Mr. McHugh's name on Google, the 6th item is an article from the Met News which transcribes the alert issued by the court. And the headline is, State Bar charges Glendale lawyer with bilking client. But as demonstrated by Judge Miles, Mr. McHugh was completely innocent. And yet he has had, and continues to have, if anyone does an online search of him, a statement that he is guilty of, or has been accused of of bilking his client, when he was entirely innocent. Now, you need to reform your mechanisms of granting of due process to attorneys, and you need to do it in the following ways, which I have brought in my conclusion, which is at page 11. The first thing you need to do is you need to stop the use of consumer alerts and posting of pending disciplinary charges on member pages. The problem you have is that when you are wrong, and you are wrong from time to time, it destroys the ability of accused lawyers to regain their reputation, because the online evidence of these charges remains forever and no one posts the exoneration. Even though McHugh was completely exonerated, Ms. Kim decided to file an appeal of it, which only after multiple articles and criticism did she finally dismiss in November of this year. Third, I took a look at the documents put forth in the last meeting of the RAD committee. It is all about number of prosecutions, reduction of investigatory backlog, and the efforts to essentially get the most scalps in the shortest period of time in front of the bar. There is no analysis being brought forth by OTC to your committee, Ms. Rosing, about the screw-ups. As far as I know, this is the first time you've ever heard about McHugh. The problem that you have is that the mechanism you are doing and the standards you are doing that you are imposing for determining the success or failure of the OTC is being based not upon the aspect of whether or not it is accurate results being obtained, but just the largest number of positive dispositions. That is a real problem. You're not looking at the quality of the prosecutions. The previous speaker suggested that there should be an independent examiner. That is completely necessary for the following reason. In the McHugh case, you have the State Bar Judge Miles essentially saying
if you just wrap up in 1 minute, I would appreciate it. Thank you.
A State Bar Judge Miles saying that the pleadings filed were pretty much fabrications, all right? What's going to happen to the deputy counsel and the particular overseers who initiated this completely unfounded prosecution and assisted in doing enormous damage to a completely innocent lawyer? The answer is no one. The answer is there's nobody to go ahead and ensure that this process is corrected. When there is an exoneration, as there was in the McHugh case, you should go out and publicly publish that on the State Bar website, saying, oh, by the way, in this McHugh guy who we accused of being bilking people, he's in fact completely innocent, and we apologize for what we did to him. And in fact, you should not view anything that you read about this as true. But instead, the only thing that you find on the State Bar website relating to prosecutions is situations where you're crowing about successes in terms of obtaining prosecutions of lawyers who acted inappropriately. And while if you're going to issue a press release in that case, you should equally issue press releases to exonerate lawyers who have been falsely accused and proven to be factually and legally innocent.
The most important thing that needs to, I've already talked about it, just know that there is a significant problem here. You talk to Ms. Kim, and that's mostly who you hear from, and that's fine. But you need to start listening to people who go through the system. They're ignored, they're considered the pariahs of the profession. Whatever they say tends to have little credibility because they have an axe to grind perhaps. They're trying to justify their own acts, saying, oh, that terrible State Bar, look at how they treated me, and it's not true what they're saying about me. When I interviewed all of these different people, I took the time to look through the State Bar files down in Los Angeles, where most of them were, to make sure that what they told me about the process was true. I didn't want to just take their word for it. So everybody who you see their little case studies in the show, I can tell you that I took the time to really make sure that they're accurate as to the process they went through. The main thing that has to happen, and this is going to take a legislative act, the State Bar Court needs to stop being your employee. The State Bar judges cannot be paid by you anymore. They cannot be employees of the State Bar. You are prosecutors. The State Bar function is to prosecute bad lawyers. Embrace that. Embrace the inner prosecutor in you. And it's okay to be a prosecutor. It's okay to be a tough prosecutor. But don't believe that you are able to then also act as an impartial judge, as an organization. The history has shown that you simply cannot do it. It wasn't always that way. What happened was when the professional State Bar Court was first set up, and it got going in 1989, you had the presiding judge, Lisa Perlman, and the first group. Prior to that, you had the volunteer system. It got a little unwieldy because you had like 400 volunteers. You're trying to coordinate. The outcomes were uneven. There were these scandals in the press right here in San Francisco, when the Examiner used to be a big newspaper. They came out with this big expose. That then triggered an investigation in the Senate, State Senate, and then that led them to hiring Robert Felmuth, who I've interviewed. You're going to see his interview pretty soon on the internet, which I'll post. I'll let you all know once he gets interviewed. Setting up this professional State Bar Court. The defense bar liked them for obvious reasons, but also they were initially getting good reviews even from the prosecutors. But what happened was, as the years went by, because I think they're served for several years, they got more and more upset by this high rate of throwing out cases brought to them by the prosecutors. So what happened was that when it came time for Lisa Perlman and a number of the hearing department judges to be reappointed, they were not added to the list to be reappointed. And they were basically fired for being too independent. She then did an interview with California Lawyer magazine. I do quote from that, but you can also look it up, where she said, any appearance of impartiality is gone. It just doesn't exist because of the influence of the bar and the prosecutors in the judicial selection process for the State Bar Court. I can tell you right now, the State Bar's never recovered its reputation after that in terms of its ability to deliver fair justice in its own court. And I think it's been proven by the case studies that I present and many people that you hear coming to you. The judges need to be separated because you also have an issue where you have the annual dues bill. And the Pete Wilson veto, I don't know how many of you remember the Pete Wilson veto back in the late 1990s. Governor Wilson vetoed the bill. It wasn't because of the discipline system, by the way. He just thought that the bar was kind of corrupt and things like that for other reasons. But he sent a message. He vetoed the dues bill, and it reached an impasse. The bar was shut down for almost a year. 500 jobs were lost. And finally, luckily for the bar, his term was up, and then Gray Davis came in. And then Gray Davis quickly approved the bar dues bill, and things got going again. But the discipline system basically also shut down. And then Governor Schwarzenegger reminded everybody here about the power of Sacramento to cut you guys off. And he also said that the bar is kind of corrupt. He cited wording from the Pete Wilson veto, saying it's still that way. But you reached a quick resolution with him. He then signed off on it, and you got going again. But it was a reminder how much power Sacramento has over your budget. You're mostly volunteers here on the board. Ms. Kim is probably the one who'd be most affected, but so are all the other full-time employees here. Whenever Sacramento, they tend to rattle the saber about, hey, discipline, you need to, you can't be lax on discipline. Otherwise, we have the power to not approve your dues bill, and you have the threat of being shut down again. Any year it could happen. So what's happened, and this has been interviews with and stories that I've seen from defense counsel, this whole attitude change with the judges, you are putting this pressure on these judges right now that if they don't produce enough numbers, if they don't produce enough disbarments and enough suspensions, Sacramento is going to get pissed. And so they're under this pressure that no other judge in the state has. They could cost you your jobs. Well, Ms. Kim's job, but not you on the board, but you won't be able to serve on the board anymore. You cannot put pressure like that on a judge. And that's why the judges have to be separated from you guys. So what we're proposing, I mean, there's a couple of ways to do that. I proposed, this would take a legislative act, is just to go ahead and shift them over to the Superior Court. I had interviewed Quentin Kopp. I'm not sure some of you probably know who he was. He was a state legislator. He's interviewed in the documentary. But he also, after that, he became a Superior Court judge. And I asked him, you know, having served in the Superior Court, you also wanted to break up the bar, but what about this idea of shifting the judges to the Superior Court? Do you think it would work? You having served? He said, yeah. He said, actually, it would be an interesting assignment for Superior Court judges to do. And you can just set up 5 departments like you have now. They could actually even still be here in this building if you wanted to. It'd be a zero financial impact, because the bar dues that you now use to pay for your state bar court, you just send that money to Sacramento, and they put it in whatever fund pays the judges around here, the regular Superior Court judges. And now you have a truly independent judiciary in the state bar. And then you guys just prosecute. You play tough. You do zero tolerance, whatever it is you feel like you need to do, because that's your job. And then you let the judges be judges.